I know what to do now.
All rise. The Court of Appeals, First and Fourth District of Ohio, Honorable Marilyn Zayas presiding, is now in session. Please be seated.
Good morning, everyone. I see everybody's thawed out. It's been rather cold, hasn't it? Well, today is Monday, January 27th. It is an honor, pleasure, and privilege to be here with you this morning. We have 4 cases that are on the docket. One has submitted, which is the first. The first case is case number C240325, which is State of Ohio versus Eric Lawson. The second case, which is scheduled to argue, is case number C240163, In Re BW. If attorneys can please identify themselves and their readiness to proceed.
Jessica Moss and Tim Chen on behalf of the appellant BW, we are ready to proceed.
Okay, thank you.
John Vogt on behalf of the plaintiff appellee, State of Ohio, ready to proceed.
Thank you. And then we have case number C240022, Alicia Owensby versus Johannes Underwood et al. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor.
Good morning.
I'm Dwayne Sims on behalf of the appellant Anderson.
Good morning.
Good morning, judges. Eric Larson on behalf of Alicia.
Good morning. And the last case we have are cases number C240256, 257, 258, In Re YS.
Ron Scrimmon on behalf of the appellant, State of Ohio.
Good morning.
Good morning. Victoria Cleary on behalf of YS, ready to proceed.
Okay, excellent. All righty, so we'll begin with In Re BW.
I'd like to reserve 3 minutes.
How many minutes?
3 minutes.
3 minutes, okay. You can start whenever you're ready.
Morning, Your Honors. May it please the Court. Jessica Moss and Tim Chen on behalf of Appellant BW. BW's initial classification here was in violation of procedural due process and fundamental fairness as applied to him in light of the Ohio Supreme Court's case in Re DR. And this is an as-applied challenge that's specific to the circumstances in BW's case. And there are 3 factors that make BW's circumstances in case distinguishable from other initial classifications. The first is that the juvenile court found that its hands were tied and felt that it was forced to proceed with an initial classification hearing. And this is
Statutorily, it was required.
correct. And this is akin to what occurred in Re DR, where the juvenile court similarly found that its hands were tied and it was forced to go forward for an end of disposition hearing and keep DR at a Tier 1 classification as a mandatory registrant, which was then found unconstitutional by the Ohio Supreme Court. The second, that there was a foregone conclusion that BW would be classified as a Tier 1 registrant. There was no dispute that BW posed a low risk to reoffend. The state deferred to the juvenile court as to the classification. The juvenile court even indicated that it would classify BW as a Tier 1 even before any information was placed on the record as to any factors. And this is also consistent with the research that establishes that children who commit a sexual offense pose a low risk to sexually reoffend.
So just so that I'm understanding, the court in DR discussed, that was a final disposition hearing that we were dealing with in DR, right? Correct?
Yes.
And the court in DR talked about the initial versus the final disposition hearing having different purposes, right?
Yes.
So in this case, we're dealing with an initial. What is the purpose of an initial disposition hearing, or initial hearing, classification hearing?
So the purpose for mandatory registrants under 2152.83A.
Could you pull the mic down a little bit?
Sure. Looks at classification. And so it's looking at whether or not a child poses a risk to reoffend, the risk to the public, and that's where when the court's looking at Tier 1, Tier 2, Tier 3, there has to be an individual determination. And when the Ohio Supreme Court looked at in Re DR, even though they acknowledged that initial classification is different than an end of disposition hearing, DR was not about an initial classification hearing. That was not what was before the court. But what the Ohio Supreme Court looked at in Re DR is where there is a critical proceeding where the juvenile, which the statute requires a hearing for the court to make a determination. When the juvenile court is divested of discretion to make an individual determination in those circumstances at this critical point, that is where there's a violation of fundamental fairness and due process.
But just getting back to, I mean, this initial classification hearing is done at the disposition, right? So this is done when the court basically sentences the child.
Yes.
Okay. And then once the child completes his or her sentence, there's the final disposition hearing where the court can determine, that was the DR situation, right?
Yes.
Whether or not that sex offender classification is going to follow that child into adulthood, right?
Yes.
Okay, so we're just talking about the court setting the classification at the beginning, right?
Yes.
And wasn't, though, that a significant difference in DR and why DR looked at the final disposition hearing differently than the initial classification? I mean, they really differentiated the purposes of these two hearings, right? Isn't that significant?
They did indicate that there was a difference, but I also believe from the decision, they indicated that in Re DS, the reason that passed constitutional scrutiny and wasn't a due process violation, wasn't a violation of fundamental fairness, is because of that initial classification hearing, that juvenile was a discretionary registrant who not only did the court have discretion whether or not the child should be classified, but also that the court had discretion to determine what tier level to classify the child. And so, because this issue has not gone before the Ohio Supreme Court as to the initial classification, this is a new issue. We are just asking this court apply the findings from DR as to what constitutes a procedural due process violation and a violation of fundamental fairness when there is a critical proceeding that requires the court to utilize its discretion in making a decision.
But here the court did have discretion. I mean, the child comes in and the court can choose tier 1, tier 2, tier 3, right? So there is discretion.
So the court does have discretion to choose what tier level. Here, it was very clear that the juvenile court was going to choose a tier 1, and there was no real consideration of a tier 2 or a tier 3, and that makes this different from other cases where it is possible that the state might argue for a tier 2 or tier 3. You might have other indications that a child poses a higher risk. Those were not present here, but the difference in the requirements for registration under Ohio, the only differences are the frequency of how long a child has to register and the amount of time the child has to register. The same procedures children have to follow, whether they're at tier 1, tier 2, or tier 3. And the research also shows that children are at risk for a number of different harms when they're required to register.
But your client is going to have the opportunity to have a final disposition hearing, right?
He will, yes.
And then at that hearing, the judge will have discretion of whether she wants to remove him from the sex offender registration list.
Yes, the court would have the ability at that time, but our argument is that the court should have had the ability at this time, and specifically for BW, the fact that the disposition plan was for him to move to Indiana, where he then is forced to be put on a public registry, even though at the plea hearing and at the disposition hearing, he was specifically told that he would not be a public registrant. Also, is important in this analysis at what constitutes a critical hearing. And so for him, the circumstances are different than other children who the plan is for them to live in Ohio and follow Ohio's registration requirements. And we know from...
Suppose the as-applied challenge, you want us to put into the calculus the fact that he was intending to move and what effect that move would have with regard to the, what it looks like to be a tier 1.
Can you repeat that question?
You were saying that when he goes to Indiana, that there was like a public registration that needed to be done that would not have been done if he had stayed in Ohio.
Correct. Indiana only has a public registry where children and adults alike
So
are
you're asking
placed.
us to put that into the calculus of as applied, the fact that this individual juvenile was intending to move to another state and what the effect of that move is.
Yes.
Okay.
And this is in addition to the fact that we know from the Ohio Supreme Court's decision in Ray RB that the end of disposition hearing can occur after a child turns 21. And so it could extend into adulthood for all children where the court does not have discretion then at initial classification to determine whether that is an appropriate classification. And so this is compounded in BW's circumstances because of the disposition plan of him moving with relatives to Indiana and Indiana's laws.
I'm just having a really hard time understanding how the court doesn't have any discretion, because in the DR case, that was a situation where the child was initially classified as a tier 1. And then you have a completion of disposition hearing, right? And what's the purpose of a completion of disposition hearing is to see if the child was rehabilitated, right?
Yes.
And so then, if the child was in a 3 or a 2, the judge could drop the child down if the judge felt the child was rehabilitated. But in the DR situation, because the child was already classified as a tier 1, the judge could not do anything. Basically, the completion of disposition hearing was pointless then, right?
Yes.
Okay. Here, we have an initial. And the initial, the child hasn't been classified at all. And so now, when we talk about discretion, the judge does have discretion to determine where to classify the child and then ultimately take the child off the list. So I'm just really having a hard time understanding where the judge lacks discretion in the initial hearing.
Sure. What puts this more similar to DR is the fact that this court likely might not have classified BW had there not have been a requirement under the statute. And the court, it was a foregone conclusion, and that makes the hearing meaningless. So the court has to look at all of these factors, and even before taking into account any of the information to show whether or not BW posed a high or a low risk, the court is saying from the get-go, my plan is to classify BW as a tier 1, my hands are tied. And so that is where I'm saying that the court lacked discretion in this particular case, where in other situations that might not be the situation, where the court may be evaluating all of the different factors to determine which tier level. In those situations, there would be discretion from the juvenile court if there was actually a question as to what tier level a child should be.
And what is it
placed
that
at.
makes this case mandatory for there to be a classification? Because that's what you are challenging, is the fact that there needed to be a classification, right?
Yes.
So what is it about this case that made it mandatory that you're asserting that in other cases would not be mandatory?
So because BW was 16 years old, that made him a mandatory registrant, and 2152.831 requires a hearing to look at tier level. And so then it falls in within 2152.83A as to the requirement for him to be classified. And this is distinguishable from discretionary registrants, where the court not only determine if the child should classify, but also what tier level to classify the child, and that's within 2152.83B.
So Ohio seems to be moving in the direction of having all of these different classifications. So beyond sexual classification, right? Based on your argument, are you generally then in some ways would agree or would believe that any time that there is a classification, and there must be a classification made, that should be challenged constitutionally?
No, Your Honor. In this case, this is an as-applied challenge to BW. So again, if...
No, I'm just saying that that's why I said should be. In other words, that defense counsel should go ahead and challenge it as applied, so on and so forth.
I think it really depends on the circumstances of the case. If there are other cases like BW's where there isn't discretion from the juvenile court, it's a foregone conclusion, that makes the hearing meaningless. Those situations would be one where it would be appropriate to challenge procedural due process and fundamental fairness, but not in every case.
Are there other situations where the juvenile court doesn't have any discretion and hearings are meaningless? I mean, is this going to open up a door to challenging other situations that are not before us?
Well, BW's case stands apart from other cases too because of this issue of Indiana, and so it is put into a separate box because of that. That makes it different. Most kids the plan is for them to stay in Ohio. You know, when we look at the difference between this and a mandatory bind-over hearing, the difference there is that the bind-over hearing, there's a probable cause hearing, and that's all that's statutorily required for mandatory bind-over. So there's not discretion built into the statute to determine amenability. Whereas with mandatory initial classification, if we're still looking at tier 1, tier 2, tier 3, then there has to be some determination by the court. But when the court then has this foregone conclusion, then discretion is taken out of their hands. So the difference is that there is a statutory requirement for a hearing to assess risk level in these mandatory initial classifications that's different from mandatory probable cause hearings.
Okay.
Thank you, Attorney Moss. I'll reserve your 3 minutes.
Thank you.
Good morning.
Good morning, Your Honors. Opposing counsel, may it please the court. So I'd like to start with I think what is the one thing I'd like this court to pay attention to, if nothing else, and that's on page 9 of the state's brief. We cite a United States Supreme Court case, Board of Regents versus Roth, and that is that to sustain a procedural due process challenge, there needs to be identified a fundamental substantive liberty or property interest identified, and that has not been done in this case. So therefore, BW's claims are deficient as a matter of law. We're not talking about incarceration, we're talking about classification.
You're
and
looking at the dissent in the DR case,
That's right.
and that's kind of probably where DR is headed. Is that the argument that you're making?
I think the dissent was correct in DR, Your Honor, that DR and other cases similar in its progeny, where there has been procedural due process decisions made by the Supreme Court of Ohio and other courts in Ohio were wrongly decided.
Well, because it raises an interesting issue as we move towards a state that we have all of these registrations. we keep adding registration lists, okay? And oftentimes, whether it's in the juvenile context, whether it's in the adult context, the bench doesn't have any discretion. Some classification must be imposed.
Yes, Your Honor, that is right. It's in the state's brief that sometimes the discretion of a trial court, at least in the context of juvenile courts, gives way to General Assembly mandate, or, the laws that are passed by the General Assembly. The Ohio State Supreme Court also noted that the Ohio Due Course of Law Clause and the Federal Due Process Clause were created before juvenile courts were created, so there's no substantive right, according to the Ohio Supreme Court, to a specific juvenile court procedure. But even if this court is going to go ahead
That's what makes juvenile courts very interesting, because it's all a statutory nature.
Yes.
It's all born out of statute.
Yes.
There's no common law. I understand the point you're making, okay? It seems to me that part of the argument this morning is sort of like a carve-out with regard to the facts of this case.
Yes, I think, irrespective of the state's substantive due process argument, that Revised Code 2152.83 is fundamentally fair, even when you look at it under procedural due process lens. Judge Krause, I think you nailed it on the head that the majority opinion in re DR in paragraph 28 noted that there's a difference in the purpose of the mandatory initial classification hearing at the initial disposition than the end of disposition hearing that goes into whether juvenile offender has been rehabilitated and what should happen to them at that point. I think unlike...
What's the purpose of the initial classification?
Your Honor, sorry, I'm getting caught up to speed on juvenile procedure
Okay.
Stuff. This was Ms. Adams' brief.
Right, I understand.
I think plainly, Justice Bruner noted that there is more of a directive to courts to consider the rehabilitative nature, or whether a juvenile offender has been rehabilitated, and that is an important distinction that the majority wouldn't have made if it weren't important. But I think unlike Revised Code Section 2152 in Re DR .84, or the In Re CP case, there is discretion here. So if the issue is whether, In Re DS that the Supreme Court decided, if they hung that on the discretion of the trial court initially to make sex offender classifications for juvenile offenders that were 14 and 15, that last beyond their disposition, if the issue is discretion, there's discretion here, as you noted, Judge Krause. It's just not the discretion that BW wants.
Going back to the carve-out, part of the argument is that what was in essence promised at the hearing would be undermined by him moving to Indiana, and that then feeds into the due process concern.
Well, I think the thing about the Indiana argument that has been raised is it was only raised for the first time on the reply brief. The concerns about Indiana, about that, whether that might have affected the fairness of the proceedings, that wasn't raised on the assignment of error. I'd ask this court to disregard it. I think that goes to the state's argument regarding waiver, and certainly there was an argument as to the constitutionality of this subsection below, but it's the state's point that when BW entered an admit plea, it still waived the challenge. I mean, BW was apprised of the classification implications of admitting to a gross sexual imposition offense. So the state doesn't have to declare waiver at trial court for it to be operative. There's plenty of case law, and we cited in our brief, that where an offender admits or pleads guilty to these offenses, you waive the challenge to the constitutionality of those offenses.
Was the plea, though, of admit conditioned on his compliance with the registration requirements? I mean, was that a condition of his plea, or did the registration requirements just happen because he pled?
Sorry, Your Honor, I can't cite you to the point of the record where that is the case. I mean, certainly, since this is a mandatory classification offense, it's my understanding that that was discussed.
But wouldn't that be a significant difference if you're talking about waiver, if your guilty plea is conditioned on complying with the registration requirements versus you just plead guilty and then you get the registration requirements placed on you? Seems to me that would be a difference. because you're not agreeing to the registration requirements.
I think in the context, I mean, of out-of-state probation reporting, which the court can grant as a matter of grace, the court didn't have to permit BW to be on community control in Indiana. I think that's an important distinction. I don't think that affects the constitutionality, that if an offender who pleads guilty to a mandatory registration offense in in Ohio, and those consequences are explained to that offender, if that offender then chooses or applies to have their probation transferred to another state where the registry situation is different, I don't think the trial court can consider that, or this court can either. And again, you know, as to kind of circling back a little bit to our point initially, being placed on a public registry, there's just no citation to case law that talks about how that is an identified fundamental liberty or property interest. Any substantive interest or, you know, attempts by BW to rebut that state's argument, again, those are raised for the first time on reply, and this court can't make those arguments for BW when they weren't made in the first place. You won't see any argument in the initial brief that there's somehow a substantive due process right
Well,
in
that's
this
because
case.
they're relying on DR, which was a procedural due process case. Rightly or wrongly decided, that's the way the majority decided the case, right?
Sure.
So they're not going to be arguing a substantive due process. That was a dissent in the DR case.
I suppose, Your Honor, I think the state's relying on the United States Supreme Court case I cited to you on
Okay.
page 9 of our brief.
All right.
Just one other final point. I know the court's obviously well aware of this, that there's a strong presumption of constitutionality in these cases. It's BW's burden to prove a constitutional infirmity beyond a reasonable doubt. And the Ohio State Supreme Court already weighed in part on a different portion of 2152-83 when it found that portion was constitutional in Reed D.C. in 2016. So unless there are any other questions, we ask the court affirm.
Thank you.
That's it. Thank you.
All right, Attorney Moss, you have 3 minutes.
Yeah. Senators, the state's reference to discretion giving way to the General Assembly was from this court's decision in Ray D.C. that solely concerns substantive due process, not procedural due process. Now, as to the waiver issue, the state's references to United States v. Stanley does not apply in this case. This was not an agreement to follow specific classification procedures. In fact, the juvenile court said it did not even know what Indiana registration requirements are. Whereas in Stanley, there was a specific agreement to those registration requirements. And we have a case from Ohio in one of our sister districts that looks at the fact that a plea does not negate the ability to challenge whether a person should be classified. And even in DR, there was a plea to that offense. There was an initial classification, and that also did not waive DR's ability to subsequently challenge the classification at the end of disposition hearing. And even if this court were to determine that this was waived at the trial court level, this court has discretion to review issues of constitutionality where the rights and interests involved may warrant it, or where there's plain error. And in this case, and again, especially given the circumstances of BW moving to Indiana, the
And while
interest.
that is true, plain error has been morphed by the Supreme Court, and there's now this requirement for it to be obvious. And I think it seems to me that it would be difficult to overcome that if there's nothing on point that has already been decided on the issue.
Yes, Your Honor,
Do you understand what I'm saying?
I do.
I mean, in that sense, it's more difficult to really survive a plain error review.
And the discretion to review constitutionality is plain error or when the rights and interests warrant it.
Okay.
We would ask that this court look at the fact that this was a critical time in the proceedings, and the juvenile court was required to utilize discretion, but they were divested of that ability to do that, given the perfunctory determination that BW would be a Tier 1 offender. He would not only be subject to the potential for ongoing registration past 21, even after the end of disposition hearing, if that didn't occur till he's 21, but because he's going to Indiana, he's actually essentially having more serious consequences than other juveniles that would be in his situation. We would ask that this court find that BW's initial classification was a violation of procedural due process and fundamental fairness as applied to him, and remand this matter back to the juvenile court to have a new initial classification hearing to determine whether BW should be classified. Thank you.
All right, thank you. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. You're an intern, is that right? Where are you in school right now? Oh, wonderful. My alma mater. Well, best of luck with everything. Have a wonderful afternoon. Owens B.V. Underwood. Good morning.
Good morning, Your Honor.
I hope everyone had a wonderful weekend. You can come forward when you're ready. You can come forward when you're ready. Good morning, Attorney Sims.
Good morning, Your Honor, and if it pleases the court and counsel, I'm going to go ahead and request the court to reserve 5 minutes for rebuttal.
Perfect.
And I'll go ahead and proceed because a lot of the argument is contained in the brief, but I want to not repeat the argument that's in the brief so much as to expand on it.
Okay.
One of the first things that I looked at when I was going through this was whether or not the necessary parties were included to form a contract. I believe that it's indicated in here that both parties were married at the time the contract was entered into. I think the court is well aware that automatically attaches dower rights to the spouses. Neither of the spouses entered into the contract. This was solely between Mr. Underwood and Mr. Anderson. Now, as the contract proceeded, Mr. Underwood transferred his interest with his wife's interest, because she signed off on it, to Mr. Anderson. So it vested in Mr. Anderson, but Mr. Anderson's wife was never involved in this
And
contract.
there was a summary judgment that Underwood filed that was granted, is that right?
Yes, there was. But there was no reasoning indicated in why the summary judgment was answered. And one of the issues that raises with the summary judgment, because the record indicates that at the time that this case was filed, Mr. Underwood had already transferred his interest to Mr. Anderson, so he never should have been a party to start with. But as a result of what the court did in this particular instance, it punished Mr. Anderson by removing part of the pay for the property that he owned at the time and giving it to Mr. Underwood as if it was a punishment for Mr. Anderson rather than a punishment for Owensby for suing him to start with. Because essentially what she did is ordered escrow funds that should have been paid, which there was no evidence that it was paid at the time that the contract was supposed to be consummated.
So I think what you're saying, let me see if this is what you're saying,
Yes.
okay? Is that whether there was a valid enforceable contract was the issue before the court.
Yes.
And before that determination, there was monies that were given to Mr. Underwood from the Andersons, despite the fact that a determination of the contract had not been valid. So we didn't know, so at that point, the court had not determined what Underwood's rights were.
Exactly,
Okay.
because it was based upon a summary judgment motion and not a hearing for finding of facts on the entire case.
Understood.
There was also a problem in this particular case procedurally, because Ms. Anderson had separate counsel that filed a motion to intervene on her behalf to represent her right to due process for her property interests.
And that was
This-
under Civil Rule 24A.
Yes, yes. And it was denied. So she couldn't even enter the case prior to the trial to defend any interest that she had in the property. So it was,
But I'm a little confused on this argument. So, because you're talking about, you started off talking about necessary party,
yes,
via Civil Rule 19
correct.
issue, which was not raised below, right? Like, so nobody raised that she was a necessary party. She simply moved to intervene pursuant to 24, right?
As far as I know, I wasn't her counsel at that point.
Right.
I never represented
Based on
her.
the record that I
Based on the
saw,
record,
I
that's-
never saw any argument under 19 made below.
Not on her behalf in this case.
Was it made
Be-
at all below?
Well, I think if it was not made at all below, then it would be what the court discussed earlier. It would be an obvious plain error in this case because it's clear that she has a property interest, that she has a dower right.
Okay, so, but would you agree, though, you could not, the judge denied her right to intervene under Civil Rule 24, right? That was what the judge was looking at.
Based upon the written documents in this case, that was my understanding of the basis that the trial court denied her entrance into this case.
And so your client would not have standing to challenge that denial, right?
He would, the 24.
Right.
Correct.
So that's why you're now arguing under Rule 19?
That's correct.
Okay,
Two different things.
okay.
So in terms of moving forward with the property issue, and I think the last point that I was trying to make, there was never any evidence shown that the escrow money was paid on March the 15th, I believe it was, when the first closing was supposed to occur. In fact, it was continued in the argument that was presented that the closing never occurred was because there were liens on the property. I think in the summary judgment motion, and I think in the facts of the case, it was discovered that the lien was $238 by Mr. Anderson, and the other lien was de facto no good because the time had expired on it within a 5-year period. So in fact, if they would have deposited the escrow funds for this case, and I believe it was 13.5 or something like that, but it was clearly enough that it would have covered $238, so the closing could have proceeded on March.
But wasn't this like, they actually tried to deposit the escrow funds and they couldn't? And they couldn't proceed with the closing through no fault of their own? Isn't that the evidence that came out at trial?
That was not what I recall from the trial.
Why do you think they didn't?
Because they didn't have the money. They didn't have the money until July when they tried to set a closing for August.
So you're saying that the evidence at trial demonstrated that they didn't have the money and that they chose to move the closing?
Yes, the facts demonstrated in this case, because I don't think there was anything that was placed of record, even though it was requested, as to evidence that the funds were in the escrow account as supposed to be on the March date. The soonest that was testified it was there for the July date.
So who testified to that? Where could I find that in the trial testimony?
I believe that was testimony of Mr. Owensby.
Okay. So I just want to, as I'm going through the entry of Judge Branch, one of the statements, and it's under paragraph 12, says, "The contract set the closing for March 15, 2021. However, the closing was canceled by the closing agent due to the existence of the liens." So at that point, she's charging the closing agent as the basis as to why the closing did not
Exactly.
proceed. So are you challenging that finding of fact?
I'm
That's basically a
saying
finding of fact that was made by the trial court.
that fact supports the concept that it was unreasonable for the closing not to occur if the parties had the escrow funds in place, because I think the natural conclusion that one could make, if the closing agent canceled the closing at that point, then there was no money in the escrow account in order to proceed with it.
Because
If
the
there,
statement that follows the statement I read is the sellers did not object to moving the closing date. So there's two statements there that are ultimately findings of fact within paragraph 12.
yes, that's
Go
correct.
to what you're arguing. here.
Yes. But if you look at 14, and I believe it was 14 in that same document, Your Honor.
It says in late June 2021, after the liens had been cleared, defendant Anderson informed plaintiffs that he no longer wished to go forward with the closing. That's what 14 says.
That was in June, all right? Now, they never gave a notice of a closing date until July, and that closing date was supposed to occur in August. So if they knew that there was no intent or no desire to proceed with the closing at that point, then the question becomes, can you terminate a contract before it comes to fruition?
So are you arguing that the contract, the plain language of the contract says that the earnest money has to be deposited in order for the contract to be formed? Is that your argument?
That would be one argument, and that would be one portion of an argument.
Okay, because it's looking like the plain language, I mean, at least the way I read it, it says that the earnest money shall be deposited upon acceptance of the contract,
Correct?
which to me makes clear that the deposit was not necessary in order for the contract to be formed. How are you reading that language to require a deposit in order to form a contract? Because it says upon acceptance of the contract.
Well, in this particular case, I would argue that there was a lack of sufficient consideration to proceed with the contract. I know that the court below indicate that it was a promise for a promise. Now, then you turn to the further argument. Can you reject a promise for a promise? And I believe you can reject a promise for a promise, which is what Mr. Anderson did before this occurred. Now, if there would have been monetary consideration to consummate that contract, and we would interpret it under those terms, then perhaps it would have been more difficult to reject or rescind the contract, because there would have been actual consideration that was paid, and it would be based upon more than a promise for a promise. So,
So just so I understand, if there's a promise for a promise and there's a contract formed, you're saying you can unform that contract by taking away the
if you
contract?
withdrew the
Taking away
promise.
the promise?
Yes, you can withdraw your promise, because there's nothing tangible at that point. If you have something tangible, then one party has come into detriment, or they have offered something tangible to create that promise. A promise is a mere word. A mere word is able to be rescinded. It's
But in
rejectable.
this case, there's a written contract,
Yes.
and your argument is that written contract contains a promise for a promise. So does the written contract hinder the promise to be changed? In this case, revoked?
In
or
this per-
rescinded?
I'm sorry, Your Honor.
Okay.
In this particular case, I don't know that the court determined that it was the written contract that was a promise for a promise, other than what she garnered from the parties' understanding of what occurred in this particular instance. I believe the exact question asked by the court was, did you intend for a contract to occur when you sign this document? And the response orally was yes. So I believe that when the court was determining whether or not a promise for a promise was formed, it was based upon the promises between the parties and not necessarily the written form. Because again, if we look at the written form, can you form a contract with only a portion of the parties that are necessary to, because they have ownership of the thing that's at stake for the contract?
Okay. And are you also arguing that if the contract, if the promise for the promise is reflected, embodied in the contract, are you also arguing that that contract is not enforceable because there's no consideration?
That's, yes.
And that would be the earnest money here.
That would have been the earnest money under one theory.
Okay.
Okay. Okay, well, I'm going to reserve your time.
Okay, thank you.
Thank you.
Good morning, Your
Good
Honors.
morning, Attorney Larson. How are you?
I'm well, thank you for asking. I'm going to jump right in here with what was noted in my brief and what comes directly from the record. The question that I asked, so as of June 22nd, you still intended to go through with the sale? Answer, in June, it might have been still, yeah, I believe so. So the promise for a promise, as he is saying, is exactly what occurred.
What was the point of the earnest money provision in this contract?
The earnest money provision was, as Judge Branch found, obviously earnest money comes into it, but a promise to a promise makes that promise and goes forward. I really want to emphasize here that we're not seeing anything coming out of the record or citations on this, either in the brief or in the argument here. It's just an ongoing but this, but that. And what it boils down to is they entered into a contract to buy a house. There was a problem with liens. The liens were resolved by the sellers, and they stated under oath in June they intended to continue, and escrow money was in and available, and I just simply don't see where Judge Branch here abused her discretion to make it such that this court can overrule her decision.
Can you help me, though, understand the earnest money provision of the contract, though? It says $15,000 as earnest money shall be deposited with Griffin Fletcher and Herndon LLP upon acceptance of this contract
On acceptance of the contract.
in a trust account pending closing, or return to the buyer if this offer is not accepted. So what does that last part mean? So
And-
we're focusing upon acceptance, and then you put the earnest money in, but what does this last piece mean?
It means that ultimately there has to be a deposit made, and it was established at trial that a deposit was made. And that money still sits in that trust
But
account.
when would it get returned to the buyer? I mean, it seems like it's leaving open that the offer somehow not being accepted.
I don't
gets to-
agree
who
with
gets to
that, and
pull out of the-
obviously I didn't draft this contract. That's
I
a
know,
Myers
but
boilerplate.
But you litigated it, and I'm just wondering who gets to pull out of the contract if who gets to decide not to accept the offer
think the
after
only
the
way
earnest
to-
money's.
My understanding of it is the only way to pull out of the contract is if it is somehow violated in some material way. Even with that language, it still would require a material breach of some kind.
Okay.
Which, in fact, as far as I'm concerned, there was a material breach, not by my clients, but you can't just say, oh, we entered into this contract. We understand that this initial closing is canceled because of liens. We fix the liens, an active affirmative action on behalf of the sellers, fixing the liens, agree at trial, yeah, we were still planning on going through with everything, and then go, oh, you know what? I changed my mind. I don't want to sell this. Sorry, bye. That's not how this can
I
work.
understand that. I want to come back to that language.
Okay.
Because looking at that language, or return to the buyer, so that fathoms that there's money deposited in order to return if the offer's not accepted. So the shall be deposited upon acceptance, wouldn't a reading of that puts all of that together and make it all make sense, is that when the earnest money is deposited, that becomes acceptance of the contract.
I think perhaps, Judge, and you may have hit the nail on the head with this earlier, I think that it lies in the difference between two people saying, hey, you put this money in trust and we've got earnest money there, verbally, versus committing everything to writing and moving forward with a real estate contract and taking affirmative actions. I hear what you're saying about it. Had no affirmative actions been taken, had anybody chosen to withdraw before taking all of that and moving forward with it, perhaps we'd be in a different situation.
Well, I want to go back to what I'm
And-
trying to.
and frankly,
what
I'm trying to find.
But I'm trying to think this
I'm trying to think
through.
of an example of what would trigger that very line in itself. And frankly, I'm struggling to
Well,
do
I mean,
that.
but, with real estate, there's money, and it's really the money that seems to be determinative of the formation of that contract oftentimes.
Oftentimes.
So, exactly, I'm going to leave it right? And so, looking at this, it seems to me that a reasonable reading that makes the whole paragraph make sense is that with the deposit of the earnest money, that's the acceptance, unless the seller returns it to the buyer, right? Now, it doesn't say here within a reasonable amount of time, but it says unless, right?
Right.
So, once that money was deposited, whenever that money was deposited, perhaps it could be said that at that point, the contract is formed, unless that earnest money is returned to the buyer.
Correct. And the earnest money has not been returned to the buyer.
So, I think what becomes critical is, when did the seller articulate that they were not going to move forward in relation to the depositing of that earnest money?
And see, that's the challenge.
And the
That's
record
challenge that
seems
I
to be
have.
kind of fuzzy on that.
I think the record is more than fuzzy. I think it's devoid of that. I think, out of the blue, it was just decided, I don't want to do this, despite the fact that they had moved forward with everything.
Is the record clear, though? This was my question to Mr. Sims. Is the record clear that your clients did attempt to pay the earnest money and it was rejected?
Yes,
Okay, so they
There
showed
is
up at the
testimony.
closing with the earnest money ready to pay.
correct.
And they couldn't do it.
Correct.
Was there anything in the record where there was testimony that they couldn't afford the earnest money or come up with it?
No, certainly not. In fact, the record makes clear that a private loan was secured from Scott Ellsworth,
Right.
and that's in both the findings of fact as well as and forgive me, I can't cite to the direct part of the testimony, but a private loan was prepared and done in March.
Right, so this was a situation where they were ready and prepared to pay this money, but were precluded from doing that because there were outstanding liens that needed to be taken care of.
Absolutely.
Okay, and then the closing was postponed, not per their request?
No.
Okay.
I
Now,
would add
those-
as well.
When were
that
those liens cleared, though?
The liens were cleared, hang on. Forgive me, I'm not
I mean,
sure. They were
according to
cleared,
the-
I
according to
believe
the
They were
trial
cleared
court-
June 22nd, 2021, the last of which was cleared June 22nd,
Okay.
2021.
Yeah, because according to the entry, the trial court entry says the liens were removed in May 2021 and in June 2021.
Correct. The
Then it
second and
goes
last
on-
lien was cleared on June 22nd, 2021.
Then it goes on to say that in late June 2021, after the liens had been cleared, that's when the seller articulates that they no longer wished to move forward with the closing. And then it isn't until over a month later that, let me see, no, that's when prior to the closing, okay, it says, the closing agent set another closing date for August 5th. Prior to the closing, the buyers deposited the earnest money with an escrow agent. So was that money that was deposited, when was the money deposited? Because that's something that should be very clear from the record.
And it is not.
It's not clear from the record when the money was deposited into the escrow agent?
There was testimony that it was deposited at the time of the loan, which was in March.
Well, there was testimony that there was an attempt to deposit, or you're saying that there's testimony that it
Shortly
was in
thereafter,
fact,
it was placed in.
that it was in fact deposited in
Yes,
March?
and
Okay.
it remains there to this day. I want to emphasize something, if I may.
Okay.
And I may be over-anticipating what my opponent will raise, but he seems very insistent on the fact that these liens were for small amounts of money. Frankly, that's not a relevant issue or a matter that really needs to be taken into consideration. A lien is a lien is a lien, and if the title agency needs it cleared in order to execute and follow through with a sale, that's what it is. And frankly, that's what happened. That's why they cleared those liens, to move this sale forward. And then emphasizing again, they testify directly, I still intend to move forward as of June 22nd, when those liens were cleared. So this is it's more an out of the blue, having the rug yanked from under them. I'm not sure if you want me to address anything as to Dower or any of those issues that
I
were
mean, you still
raised.
have time if you'd like to address.
I'll do it briefly. I hear the Dower argument, I hear what was said. I don't think we have anything that raises an issue that says that Judge Branch abused her discretion here, inasmuch as any Dower arguments were raised quite literally on the eve of trial.
Well, he's raising a necessary party argument now.
Right, and 19 is different than 24, and it wasn't raised below.
It is, because it's jurisdictional, right?
I don't believe that that Judge Branch abused her discretion, whether it was jurisdictional or not, because she received the motion, again, on the eve of trial, and went through each of the elements as to, obviously, Rule 24.
Does he even
But
have
19
standing? Does he even
19
have
has never been
standing
answered.
under Rule 24?
No.
To make that argument to us?
No,
I would think the wife would have
he
to.
has absolutely no standing, and the wife hasn't appealed anything.
Okay. But he is raising a Rule 19 argument here in front of us.
Here and here alone.
Right.
So, I don't know if you have any more questions. If you do, I'm certainly here and available. Otherwise, I will sit down.
Thank you.
Thank you, judges.
You can start whenever you're ready.
Your Honor, I read over this because I was listening to counsel's argument. And I guess one of the things that the court was concerned about was the deposit of the escrow. And assuming that the escrow deposit is tantamount or is essential to the formation of a contract, then if they're suing for specific performance under a contract, then it was incumbent upon that party to show that that deposit was made at a crucial time. The testimony was, as counsel admits, that they were advised by the escrow agents, who were people they chose. They wrote the contract, and they were told not to consummate the contract, essentially, if that's an element that the court determines is appropriate to look at to see if there was a contract that was formed. So, being that they told them not to deposit in March, then I assume then we're in agreement that there was no contract formed, if that's one of the things that the court determines is important to look at. So the next question
Well,
is,
I
if we-
think an alternative to that is if there's no determination, no finding of fact as to, but yet there is testimony or evidence, but no determination as to when the escrow amount was actually deposited, would be a remand for the trial court to make that
yes,
determination,
yes.
because we're not finders of fact.
Right, exactly. And I don't think here there's sufficient language or factual finding to determine that, because if the court looks at item 15 of the trial court's decision, it says prior to the closing, but it starts a new paragraph and it says the closing for August the 5th. So we can assume, based upon the language and ordinary interpretation, that by August the 5th, it had been deposited. However, there was a rejection of it prior to that August the 5th date, and I believe that rejection occurred in June of 2021. So I guess if there was no formation of a contract based upon the deposit of that escrow money, and there was a rejection before the contract was actually consummated, then we didn't have contract to be enforced to start with. Now, the court did ask a layman, did he intend to form a contract? I mean, I intend to do a lot of things, but does that mean that I do them if I don't complete the actions that are necessary, or if my conduct is relevant or based upon the conduct of another person to complete? No, it's not. I haven't done that.
Well,
So,
yeah, I mean, it seems like the entire case revolves around whether this earnest money was required in order to form the contract. The trial judge said, no, it wasn't, right? And you're
That's
saying, yes, it
essentially-
was. And
yes.
Because there was no earnest money deposited, no contract was formed. is
right,
the
and
argument.
that's coupled with the other arguments that are secondary in this particular case, because we still believe that those arguments are relevant in terms of looking at the total case. But it seems very clear on its face with the trial court's decision that that earnest money was dispensed of in a way that she decided was irrelevant for purposes of determining whether or not there was a contract here. We don't believe that was a proper way to dispose of this case at that particular time, and her finding of facts does not support her manner of disposing with the case and forming a contract according to her opinion.
Thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision.
Thank you, Your Honor.
I hope you both have a wonderful week. All right.
No snow and no zero.
Well, I don't know.
Right.
We'll see. I think we're going to have a day that's going to warm up in between there. In Ray, why yes? Good morning.
May it please the court and counsel, the state would just point out that we are operating under the law in AC.
Okay.
And my understanding of AC is that there was nothing in the record to bind the juvenile court to the plea bargain. And so in this particular case, the state ordered the record of the original plea that was held in June 28th, 2022, or 18th, somewhere in there. think it
And
was
I
June
believe
28th.
that the state has not appealed in Ray AC, is that correct?
Yes, it was accepted in the Ohio Supreme Court. I had to call because it just was strange how the.
Okay, so it was appealed?
It was appealed. It's in the
Okay.
Supreme Court. It's being argued at Monroe Central High School on April 23rd.
Okay, okay. I don't know why I thought when I looked it up, it showed that it was not appealed, but it was appealed.
It was appealed,
Okay.
and that's where the argument is, yeah.
Understood.
It's,
At Monroe High School.
Yes, they're having a. one
Where
of
is
their road
Monroe High
shows.
School?
I don't know. I gotta find myself.
But you're gonna find out,
I
yes.
hope it's south of Columbus. So, then I don't have to stay for the night. But We did order that original transcript. I do
Okay.
think that with that transcript, we have complied with the ruling of AC, should AC be upheld in the Supreme Court, because on page 18, on page 23, the trial court clearly indicated that if YS would file for early release, it would be not denied, and asked repeatedly, do you understand that? Yes. The colloquy between the trial court, AC, and AC's counsel was very detailed. It went through everything in the plea. And as such, the state's position is that under the holding in AC, the trial court clearly, the juvenile court was bound by that plea and the early provision that was raised in that plea.
The trial court also signed the plea agreement, right? Here.
Should have, that's a good question, Judge, because.
I mean, I think I saw her signature on
Yeah,
it.
because they incorporate it by reference and sometimes sign it and sometimes don't. And, I don't know the legal significance when you have the judicial entry signed by the court and it, the plea agreement itself is referenced in there, but.
And doesn't, in this case, the judicial entry actually use the word that the plea is accepted?
Yes, it did.
Okay. So we've got some different facts than AC here.
You do have different facts in AC. You do have some different facts.
So if this language that you're saying the trial court was bound by, because we're talking about a breach by the trial court, right? That the trial
Or AC for filing early release, because, either way, yeah.
But the language, if this language that you're pointing to was not in the plea agreement, would the trial court have the power under 2152.22A to sua sponte grant judicial release?
We would suggest no, and that'll be the issue, I think, probably that's going to be discussed in AC.
Well, no, I mean, I'm saying if the language were not included in the plea agreement about no
Oh,
judicial release.
sorry,
I'm
yes,
just,
I misunderstood.
if that language were not in there, the trial court then, under the statute, would be able to, even without a motion,
Yes, Judge, I misunderstood.
Grant judicial
I'm sorry.
release, right?
Yes, I believe so.
okay, so the reason why you're saying the trial court can't do that here is because the trial court made indications through what we just discussed that it was going to be bound by the language in the plea agreement.
It's bound by the language in the plea agreement, yes. There was indication, so we have here is what I believe this court was asking to do in AC.
Okay.
That's our position. And then I'm very bad at reading courts and especially the Supreme Court and their decision. I don't know if the court will want to hold this in abeyance. It doesn't have to, because there's different facts. You really don't have to do it if you don't. I mean, but you never know.
I think
what
it's
they
a
might
matter of
say.
timing and how, we don't know what's going to happen with this case. We don't know how it's going to be
Exactly,
written, but it might wind up getting joined, and then perhaps there's a bigger determination than the,
Yeah, I would
narrow
be very
facts of AC.
poor if I tried to predict the decision.
yeah.
So the language, though, in the plea agreement does not prohibit the juvenile from filing for release, right? It simply says the juvenile will not receive release.
Receive really, you know that it is an AC, definitely, and I could be conflating the two, but you can't file, or, I know the judge at the plea hearing said, if you file for early release, it will be denied. And
Right.
that's on page 18 and 24.
Which is your argument that the judge intended to be bound by the language.
Exactly.
But
That's
that
exactly
goes
right.
more to the breach by the judge versus a breach by
That would be the
juvenile.
breach by the judge,
Okay.
right. That's correct, under the language. So, I'm sure the court's familiar with sort of the issues and what we were attempting to do here, and I would leave it to the court's discretion on whether or not to rule before AC or not. That's a tricky one for me, but, and even, I think the court could, but, I don't know. You don't know what they're going to say in AC at all.
So in AC, whatever, I'm not going to make you argue AC.
No, it's just.
We'll see what happens.
Right,
It's
thank you, I just appreciate it.
But your main point in that case was that the transcript of the juvenile court's plea hearing was not necessary in AC.
That's the argument in AC under the presumption of regularity, and who knows where that's going to go. I'm not.
Okay.
I'm at least hopefully intelligent enough to not to bet on how that's going to go. So,
Exactly.
But in any event, can reserve a few minutes if I need it otherwise.
Yeah, I totally overlooked asking you, so I'll reserve.
Okay, great.
Okay.
Thank you.
Good morning, Attorney Ferry. How are you?
May it please the court? My name is Victoria, and I'm here on behalf of YS this morning. So today, the state argues in its sole assignment of error that the juvenile court specifically, not YS here, erred when it granted YS's release. Specifically, the state contends that the juvenile court breached the agreement by granting a motion for early release. However, there are several issues with this argument. As within AC, the record does not reflect that the trial court intended to be bound to this term and is therefore not bound to enforce this clause. Specifically, this court set forth two important questions.
And I have a question that I want to ask for clarity,
Yes.
okay? Is your position that, under the facts of this case, that the court didn't bind themselves, okay? Okay, with regard to early release? And are you also arguing, or are you not arguing that that there aren't, like, that the court cannot waive their authority to give early release, which is a broader question than the facts in this case? Are you arguing both, or are you only arguing the first?
Yes, Your Honor. So the way that we raise this, we believe that with AC, this court can draw the conclusion that it did not intend to be bound. However, if it finds that it is, those were how we raised those alternate arguments for the purposes of preservation.
So you believe that there's no circumstances, there isn't anything that the court could have done differently, because there is no circumstances where the court can bind itself to not be able to hear a motion of early release? And for
Yes.
that to be a term of that will always be an unenforceable term of the plea agreement if it's therein?
That is correct. We don't believe the court has to reach that. Here, that it is enough just to look at the entry itself. So specifically with AC, there was two important questions. The first being, on the record, was there sufficient evidence that the juvenile court intended to be bound to this term? And then the second would be that whether the judgment entry noted any limitation on the juvenile court's authority to grant judicial release. And the answer to the first question, our position is no, there was not sufficient evidence. Although the transcript was included and they did outline the terms, that was in the context of going over the plea agreement.
But didn't the court also inform the juvenile that she would not grant the release?
That it would be denied.
That it would be not, yes, if it was filed, it would be denied. So isn't that indicating that she will abide by the terms of the plea agreement?
No, Your Honor, again, this was not mentioned at all in the entry. I view.
Wait, I'm not talking about the entry,
Okay.
just the transcript.
Yes.
So the juvenile court, when she's going over the plea, and the language in the plea agreement with the juvenile says, and something to the effect of, I'll deny it, or I won't grant it, right? Doesn't she indicate that?
Yes, if you did, it would be denied.
If you did, it would be denied. So isn't that enough to indicate that she was agreeing to be bound by the terms of the agreement?
No, Your Honor, I believe that specifically the court only stated that on the record it would accept his plea of admission. Not specifically, although she did go over that. And I believe it's important to distinguish that the state here is specifically arguing that the juvenile court breached its
Right.
part of the agreement, not
Right, and the
YS
law is
or-
that the court has to make some sort of indication that the court is going to be bound or agrees to be bound by the agreement, right? And
Yes,
so
that's correct.
here you have her saying that she won't grant the judicial release. She tells this to your client, right? And you also have an entry that says she accepts the agreement.
Specifically, it was made in accordance with the agreed plea, but I think that this is still, AC is still on point here, because that was also, that language, what was included, but that court viewed that as the juvenile court merely acknowledging that the disposition complied with the agreement.
In AC.
In AC.
But what we have here is an entry that says there's a plea agreement that had been reached by all parties and is accepted by the court. Right?
Yes.
So we have a specific entry that says the court accepted the plea agreement here.
Yes, but nothing noting its limitation on, specifically as it relates to.
But if it's accepting the entire plea agreement, why would you have to limit why would you have to say anything else?
I think that because it speaks to the overall purpose of the juvenile court, and I think this is when our alternate arguments kind of come into play. So if this court finds that there was sufficient evidence that the juvenile court intended to be bound, I think it's important to understand what this blanket rule, the issues that it would create.
And I understand, and I just want to pause for one little second. What's missing here? What is it that would have made it enforceable in this case?
Language in the entry specifically noting its limitation.
Its limitation saying, I will not consider here, grant any motion of early release, something to that effect.
Yes, Your Honor.
Okay, so incorporating it is not sufficient. You're saying it needs to be specifically articulated.
Yes, Your Honor.
But as I understand, isn't the judicial entry in this case considered to be the entry along with the plea agreement? Isn't the disposition these two documents working in concert and in other words, it winds up being, I think, 3 pages or 5 pages or something to that effect?
I believe, again, this court in AC had something similar with that language in the plea agreement, and it
Right,
still found that.
which is why I wrote the dissent, but we'll stick to the majority.
Okay. So I would still say that in line with AC, although it's incorporating it, this court still found that, again, that it was just acknowledgement that it was abiding by the
Okay.
plea agreement.
So even though the disposition is 5 pages, including the plea agreement, it's your position that separately in the judicial entry, there should be a discussion on early release by the judge?
Yes, Your
Okay.
Honor.
So that, I appreciate you answering that question, so that I can fully understand where you're coming from. And then you were going to go into why this is not enforceable generally as a matter of law.
Yes, so even if this court finds that the record does demonstrate that the juvenile court adopted this term and that there was sufficient evidence, I think there are a number of arguments that stand alone that would make this a larger issue. Specifically, the argument that we raised that a juvenile court cannot contract around its statutory authority and what that would mean to strip its authority, especially given the rehabilitative nature of the juvenile court.
So is it because of the nature of the court that it can't contract away its inherent authority? Or is it also a constitutional issue?
Specifically, we raised this, that the revised code foresees and supersedes any sort of restrictive argument.
Okay, all right.
Does that
Because
answer your
No,
question?
it absolutely does, because this is all a nature of statute, right?
Yes, that's correct.
So that's what makes this sort of interesting to me, because as you know, and I think we can all agree, there are many constitutional rights that could be waived pursuant to a plea agreement, okay? And so it's interesting that your argument is that a statutory right cannot be waived, but a constitutional right can.
Even without that, I believe that a contract that essentially would be contrary to public policy would not be allowed here, and that was another alternate argument that we raised here.
I'm trying to understand how this would be contrary to public policy, because it's my understanding that in this case, the agreement was entered into in order to avoid bind over to adult court. And so, and to keep the child in the juvenile system, which is probably, I mean, we would think a good thing. So how is that contrary to public policy to engage in this kind of negotiation and to agree, okay, yes, if we keep the child here in juvenile court, there will be no early release because we want to rehabilitate the child? I just don't understand that.
I believe that they can certainly agree to an amount of time. I think that the issue here is that given the state's position, they are saying that the goal is rehabilitation. So even if this child, as with YS, has exercised all the programming, all the schooling, that the juvenile court then has no discretion at a later date, even if rehabilitation is met and public safety is met, that this child cannot be released into the community. And judicial releases are very rarely granted. This is, as it's shown by the transcripts, there was extensive testimony and argument specifically discussing YS's progress, rehabilitation, and his own efforts here.
But aren't we going to be taking away the ability to bargain for, you know, not having a bind over? I mean, isn't that going to be taking a tool out of defense counsel's belt that they won't be able to, I mean, why would the prosecution then enter into such an agreement? I mean, they want to have a guarantee that the child is going to be in the system, monitored and watched, and engaging in rehabilitation for as long as possible if they're going to not seek a bind over, right? So aren't we kind of going to be handicapping plea agreements then?
No, Your Honor, to the point you made about supervision, again, YS is on supervised release here. The state still has, at any time between now and when he is released from his supervision, to make sure he's abiding by that. So that's still achieved, whether that child is incarcerated in a facility or a step down, or in YS's cases on parole. I believe that's still achieved. He's still being monitored. We really view this as the next stage of rehabilitation, where he will have access to reentry sources. Specifically, one of the programs that he applied to was only available till 21, and that was not only provided him with employment opportunities, but helped find housing and things like that. So we really view this as, and this was argued below as well, that this is just the next stage of rehabilitation. Do your honors have any more questions as it relates to the alternative arguments? I know there was a number of them, so.
Was there anything else that you wanted to argue?
My final point that I think is most important, that even if this court finds that the juvenile court did bind itself, that as it relates to YS, the juvenile court did not abuse its discretion. We have a child that, even with the slow staffing and issues that DYS has had, that engaged in programming, went above and beyond in his schooling, and even found outside programs to engage in. And I think that is really important to keep in mind here, that if, what the state is essentially arguing is that even if YS for the past month has been doing well and going above and beyond, that he will be forced to go back for a year and a half, even if he has exercised all the possible resources that a DYS facility has to offer. So we just ask that this court affirm the lower court's position.
I just had one quick
Yes.
question. Is it significant here that the juvenile court actually signed the plea agreement? I thought I saw the juvenile court's signature on the plea agreement.
Yes, that is correct. Again, it's my understanding that AC was similar in the sense that it incorporated the plea agreement. I don't find that the
Well, I didn't see anything in AC where the juvenile court signed the plea
Signed
agreement,
the-
so that's why I was curious if that was.
Again, our
significant.
position is that it speaks through its entries, and it did not specifically state anything about future
Because it needs to be
prohibition.
explicit.
Yes, that is correct.
Okay. I do have a question, because
Yes.
you are here on behalf of the State Public Defender's Office.
Yes, that is
How is
correct.
it that this came into the hands of the State Public Defender's Office? We're accustomed to the Hamilton County Public Defender's Office.
Yes. So I actually represented YS in the lower court as well. This was originally filed pro se, and they requested someone at our office represent him at the hearing. So
Understood. And was that the same with AC as well?
they may have filed a motion on behalf of AC as opposed to pro se that was later. I believe that.
Because didn't your office also represent on in Ray AC?
Yes, that is correct.
All right.
But I believe staff from my office filed the motion as opposed to this was originally a pro se.
Okay, all right. Thank you so much.
Thank you.
May it please the Court, a couple of clarifications. I just took a look at a copy of the plea agreement, and the judge's signature is on this one, so you're right, Your Honor, it is on there. The other thing is, I would just, looking at page 18, and this is where I got a little confused, is after the judge thoroughly went over the terms and conditions of the plea, the juvenile court judge says, during that time, you have no chance of early release or probation. Do you understand? And YS said yes. And then over on page 23, it's said just a little differently. And then the court says, you understand what's going on here? Yes. It says YS. The court says, and you're also saying that you will serve your entire term of incarceration at one of these facilities and not apply for early release, and if you did, it would be denied. So that was the exact language, I think, that binds the juvenile court to the plea. As far as the overall picture and policy arguments, there's some interesting testimony in here by Officer Zopfi, who was there to help YS because apparently someone was murdered and it was intended that YS be murdered, and he was there and was kind of against some of these early grants of early release, because what happens is most of these offenders are older, and we can't forget the two victims involved. These were armed robberies. They had guns to them in one incident, the one at the gas station, and shots were fired. We know that YS had prior contacts with the juvenile court system. It says so on page 9 of the early release hearing. So we're not talking about nonviolent offenders. We're talking about very violent offenders. And what we're doing, and Zopfi, officer, indicated that most of these early release hearings, they have been granted, and been granted against individuals who've been returned to the Justice Center. It's in the early release record. And that was Zopfi's concern, is that, what we're doing is, like you said, Judge, the state is giving a plea bargain that we think is pretty one-sided to a violent offender because they are a child and because juvenile court is a rehabilitation facility, and we're trying to keep them out of adult court where they're exposed to those influences that are arguably worse. All we're asking is that they stay there for 21 years, and if they are doing so well and they're being rehabilitated and everything's going well and they're taking advantage of everything that's available to them, that would be thrilling to the state. That's what we want. And if that means they stay there a year or two more, they're doing well, that they can do that. It's not like forever. They've just been given an extra chance here after committing violent offenses to stay within the rehabilitation.
I mean, what you're saying is that that YS got the benefit of what he bargained for.
Very much so.
With the state.
We could have bound him over, and I'm afraid that if plea agreements aren't enforceable, and we can't tell Mr. Huber, the victim, and if I'm pronouncing correctly, Franco Pacu, the victim of these very violent offenses that were shaken up, that, hey, here's the deal. We are going to let YS stay in juvenile court. YS will be incarcerated or at a DYS facility until 21, and then, there's very little collateral consequences now that go with a juvenile adjudication compared to being bound over to as an adult. We're not talking about minor offenses here, and the victims are sort of being forgotten here. And I think in the long haul, so are the offenders, the juveniles. I don't know that, if we can't ensure that these plea agreements are going to be upheld, then you're less likely to grant or to be involved in a plea bargain like this, that truly we're trying to work with both sides.
Right.
We bargained with defense counsel to get this. They were thrilled, and they asked the court twice to impose the agreed upon sentence and plea in the record, and so did the prosecutor.
And
So,
what I hear you saying is that if there is a determination, whether it's by our court or the Supreme Court, that, that the bench is prohibited from abridging their statutory authority, okay?
Right.
Pursuant to the early release in this specific case, that will undermine, it's the same thing that Judge Krause said, it's going to take away that tool from the defense. But it seems to me
may.
also if this is determined on the facts of this case,
yes.
and if the court were to determine that every term that is in the plea agreement, regardless of whether that it's been accepted and adopted by the bench, must be incorporated into the judicial entry, again, even though the plea agreement might be considered part of the judicial entry, then the other side of that coin is that if there's something that that defense bargains for and is in the plea agreement, and it's not, that the state can rescind it as well, like restitution.
Right,
Let's
right.
say that there's $10,000 of damages, but part of the plea agreement is that $100 is going to be paid. But that doesn't get incorporated, even though it's accepted, even though it's incorporated, then the state can rescind those terms that were bargained for,
Right.
that the state got the benefit of, and say,
Exactly.
okay, now I'm going to go after that because, and it's not enforceable because it wasn't in that piece of the entry that's entitled judicial entry. Do you understand what I'm
Right,
saying?
yes, because whenever there's a breach, it's specific performance or rescission, contract law applies. So it doesn't matter, either party.
It could
can
be
ask
either
for
party,
specific
exactly.
Performance or rescission, yes. So we think here that the state, went out of its way to try to help YS. We know he had, his father was murdered, and I think this was not an easy plea bargain for the state to enter into. You're dealing with a couple of victims that were pretty shaken up by this. And we got to protect them too, and we can't forget about them, and at the same time help rehabilitate YS. I thought it was a very good deal for YS, and so we just, and now we know how to comply under AC, and we'll do that, and hopefully we can move forward and have this as an option.
And I understand, I mean, it's certainly, both of these young men seem to be very commendable as to how they have, embraced the resources and have really moved forward with their lives in a very positive way. So I think that also needs to be recognized.
It does, as far as we know they have, and others haven't. You have to use a crystal ball, and we need enforcement of these deals to keep them going so we can have success stories like this. Otherwise, I think prosecutors are going to be reluctant to enter into them, for good reason, because they're generally older and usually they're more violent offenders like AC and this one. So. Anyway, thank you very much for
Thank you
listening to my
both.
arguments. I
Yeah.
appreciate it. Thanks.
Thank you both for your arguments this morning. And thank you, I know that some of the questions were not easy, and I really appreciate your candor and your willingness to answer the questions. This concludes the hearing for today. Thank you.